Good morning, everyone. It's Adam, and we're back with the Treat Planners podcast episode. And I'm joined by Teresa. And could I get you to say your last name? I'm worried the pebbles in my mouth, marbles in my mouth. I'm going to butcher it. McClellan.
McClenaghan. You don't say the
McClenaghan.
G. Yeah, it's a tough name to pronounce.
I should know that, and I should have probably practiced it before because I have a
All right.
similar. I said it silently in my head, but that's not the same as actually using the mouth sometimes. So
It's like practicing French. Yep.
yeah, yeah. So my last name is currently Balla, Ballah. But when my ancestors came over, it was Ballagh. So the
Ah.
Irish Balla, yeah. So the silent G there as well.
Mhm.
And Teresa is executive director of the Canadian Environmental Law Association, and she's joining us today to talk about water. So, as we started off, she pointed out that that's a really broad topic, and really what we're hoping to focus on is drinking water.
Mhm.
And I thought so, and there, as you noted also earlier in the green room, that there's been some pretty significant changes that have been happening with respect to drinking water, happening and potentially happening. So proposed changes as well, and this it's an interesting issue for Ontario because we have had a history where people have been severely injured and as well died as a result of issues with drinking water. And those issues have linked back to how drinking water was regulated. And then there have been changes as a result of that. This is, of course, Walkerton that I'm talking about.
Mhm.
And it's been a while since Walkerton, and perhaps memories are starting to fade a bit. And the public maybe is kind of slow walking into a situation where perhaps we're exposing ourselves to some of those same conditions that led to Walkerton. So I thought that might be an interesting way to frame the conversation, is thinking about Walkerton, what happened there, what changes resulted from that, and then kind of looking at where we are today.
Mhm.
But perhaps you want to kind of start by giving a little introduction and background on SELA and what you guys do.
Sure. Yeah. Thank you. And thanks for having me today, Adam. CELA is the Canadian Environmental Law Association, as you said, and it's a specialty legal aid clinic. It was formed in 1970 by University of Toronto law students and then funded as a legal aid clinic in the mid 70s. And we're part of the legal clinic system across the province that provides representation to members of the public who qualify for our services, and also summary advice to all kinds of people everywhere, including sometimes members of provincial parliament and members of the media, as well as members of the public. We also provide public legal education and participate in law reform. Sometimes we might write a model law where we think a law needs to change, or we might react to and provide advice to government when they're consulting on changes. And most legal clinics do those things, and specialty clinics in particular do in their areas of law, and we're the only legal clinic for the environment across the province.
What would summary advice be?
So that's where people want to know how the law works or have some information about how they could tackle their problem without us becoming their lawyer. So we
Okay.
can provide a couple of hours of assistance to people in all kinds of matters that might have to do with they see a proposal for some kind of facility being located in their neighborhood, and they're concerned about how to participate in that decision making if it's going to produce air pollution, for example, or they may see a proposal for land use changes or for changes to provincial law and want to know how to participate in those, or they may be already impacted by an activity, that's causing a nuisance, and we can provide them with information about how to deal with that, as well as our private bar lawyer referral list to take it further.
Okay. So it just gives them a sense of where they stand with respect to the law, and then also whether it might make sense for them to pursue it further and get into with some of the costs that might go along with that. And this is in case anybody listening is like, oh wow, that is great potentially for me because I have an issue with that. Where would they find you?
So our website is the easiest way to do it. It's www.cela.ca, and there is information about how to phone the office or email the office, and there's also an intake form that's just about to be posted, I think in the coming days, that people can fill out more information online and send it in that way as well. But if you email us, our students will give a call back and take down the information and then go over it with our lawyers, and then we figure out how we can help.
Great. Okay. Okay. Well, let's move into the water. We actually have our time's a little bit truncated today, so there's some more questions I'd like to ask, but I gotta be disciplined. So maybe let's start with Walkerton, I guess. Are you?
Yeah, I can talk about what happened at Walkerton, and then how that tragedy occurred, and then what resulted in terms of preventing it for the future. So Walkerton occurred in the spring of 2000 after torrential rainstorms. There was an inquiry afterwards because 7 people died from drinking what was supposed to be municipally treated drinking water. We found out afterwards that it wasn't actually being treated because the chlorinator was offline. And what Justice O'Connor found when he conducted that inquiry in Walkerton with the people of Walkerton following the whole proceeding is that many, many things had gone wrong at once and one after another in order for that to get to the point where it could make people sick or cause them to die. And those included the fact that the operators of the system weren't trained and had been grandfathered into their certification. There weren't requirements for training that applied to them. That even the people like environment and health units who oversee the system didn't understand that contaminants in groundwater can make you sick, as they testified at the inquiry. And so they were relying on voluntary measures for the town of Walkerton to come into compliance with some issues going on with chlorination. The chlorinators were turned off because they were in the middle of swapping them out. And the well supplying most of the town at that time was very shallow, and unbeknownst to the farmer nearby, who was properly storing manure on a concrete pad, but the rainstorms were so severe they washed that off right into the well, which was at the corner of his field. And then something else that wasn't understood at the time is that the geology was fractured karst limestone with cracks through it, and so it made it very fast for that contaminated manure, which happened to have very serious pathogens in it, to infiltrate the whole drinking water system. And then because labs had just been privatized, the new lab that Walkerton had just switched to didn't know that they should let health units or Ministry of Environment know when they saw adverse results, and sent them only back to the operator, their quote customer, and that operator actively concealed those results from anyone while the health unit was trying madly to find out why people were getting sick in town. So the inquiry recommended a multi-barrier approach, we call it, to protecting drinking water, and a whole range of laws to go with that. And those were implemented over the ensuing several years. And as a result, municipally treated drinking water in Ontario today is very, very well protected. There are areas where we definitely still need more more work. But and I can get into that a little bit in a few minutes. But in terms of municipally treated drinking water in Ontario, it's very safe. And regardless of what else we talk about today, I don't want anyone to leave with an impression that that isn't the case. But there are lots of people drinking water that's not municipally treated drinking water. So that's one issue, and that's not because of recent changes. It's because of the reluctance of the Ministry of Environment to go ahead with some of the original recommendations. And those, just to let your listeners know, I think some of them would be in your community actually, is that anybody who's not on municipally treated water maybe or likely is responsible for their own water through a well, and that could include whole towns and villages and hamlets who are all on their own supply and nobody else is monitoring that water. So they should take those samples to the health unit a couple times a year for testing. Some municipalities, not many, but some, especially in Eastern Ontario, are not covered by source water protection. And this is the first way we try to protect drinking water, is we try to keep contaminants out of the source around where the well for the municipality or the intake from the lake is located. And that's under a statute called the Clean Water Act. So not all municipalities are covered by that, so we think they all should be. And then everybody who's on their own supply basically isn't covered by that either, even though there are ways to have them covered, at least when there are several in one place, and we should think they should be. And then First Nations, only a few are covered in Ontario's system. They could opt in, but most haven't. So those are some areas not covered, like for that first thing we call a barrier in the multi-barrier approach. Yeah, so that's what changed. Standards were adopted, training rules were adopted, requirements for licensing of drinking water systems were adopted, strict rules, oversight, reporting. If you get adverse results, they have to be reported by the lab, not just to the utility or operator, but also the health unit and Ministry of Environment. There are rules now around boil water advisories and notifying the public if something's wrong. And so we have a really, really good, robust system for protecting municipal drinking water today in Ontario, and all of that is still in place.
And the key term there being the municipal
Yes.
water system.
Yeah. So anywhere where the municipality has an intake, either groundwater or surface water, could be a lake, a river, or groundwater through a well or a series of wells, they are monitoring the state of that water coming into the system. They're disinfecting it. They're inspecting it as it travels through the system in the distribution pipes. And they're keeping records about that. They're reporting to the Ministry of the Environment, and they're alerting the public. There's also an important provision about municipal councillors now having a duty of care under the Safe Drinking Water Act, which means they have to pay attention, ask questions, and ensure that their community is providing safe water. They can rely on their professional staff, but only if they're, actually asking the questions and paying attention.
Okay. So people with private wells aren't covered by this.
Right. They're covered. The only thing they have two things. Both are important. One is that when they get their well drilled, if they're on a well, not a lake, but actually into groundwater, by a professional well driller, then there's a regulation about what that well driller has to do in terms of protecting the security of that well, about putting in something called a casing to make sure things can't get in from around the side of it, and recording its depth, and then initially disinfecting it. They don't keep disinfecting it. That's up to the homeowner or resident if they want to add treatment to their private well, because nobody else is doing that. But the well driller will do initial disinfection to make sure that, because you inevitably will get a little bit of dirt and so on as you're drilling, to make sure it's left in a sanitary state. The other important protection I mentioned already is that people can take their drinking water samples from their wells to their local health unit free for bacteriological testing. So this does not cover chemicals or anything else besides the kind of basic indicator bacteriological testing. But nevertheless, that's really important for people to do that at least a couple of times a year. And I think lots of people don't realize that. And then the health unit will give them the results quite quickly. And if they see indicators that tell them something's getting into the well, which could be sort of leaf litter, dirt, that kind of thing, they will indicate that. Or if they see E. coli, not necessarily the harmful E. coli like Walkerton had, but any E. coli, it tells you that there's a surface water source because that's from mammal gut. And there's a pathway. So in those cases, they would need to start boiling their water right away or get an alternate source while they figure out what's happening and fix their well.
Okay. Now, I might be jumping ahead a little bit, but when someone hears a private well, they would think of an individual property owner. Like they have their well on their property. Are there other examples of private wells that, for instance, service communities?
You can have some, for example, we often call it estate residential development in Southern Ontario. Those are regulated as small systems under the Safe Drinking Water Act. And a whole bunch of small systems, like at a gas station out in the country or a summer camp serving the public, are regulated.
Okay.
But where you have, but you could have whole towns and communities with everybody with their own wells. So I live in Brant County. So all around me, there are many, many communities of many thousand, like 7,000 people in the same community with no treated water. Everybody has their own well, probably into the same or similar aquifers, with all of the risks around that. So I actually am quite worried about that. And that's why I do want those systems covered by source water protection, because they have no other protection. They have no treatment. Nobody else is monitoring it except them deciding to take something to the health unit. Nobody's giving them overall advice. And there could be agricultural activity, industrial activity, fuel and pesticide storage, et cetera, going on in those aquifers, just as there could with a municipal well. So it's quite concerning, and the Ministry of the Environment has actively discouraged including those towns in source water protection, and instead encouraged voluntary measures. And SELA, my organization, does not agree with that, because voluntary measures is basically one of the things that led to Walkerton, and they're not sufficient to provide any kind of rigorous protection. So this is something we still advocate for, is inclusion of those systems in Ontario's Clean Water Act, source water protection.
I guess one distinction also between a municipal well or water system and what you described would be the municipal, their point source where they draw the water from is identified, and they have a better sense of kind of the inputs into there. Whereas with what you were describing, it sounds like there's multiple points of withdrawal, and then it's very difficult to really understand all the inputs into that much larger area.
It's still very, very feasible to do. So before we actually had the legislation passed in Ontario to establish source water protection, the province had already provided funding to municipalities to do really good vulnerability mapping across watersheds, showing them where, what kind of the pathways could be, what kind of geology they have, how fast would water move from surface to groundwater, et cetera, what's the regional flow regime. So if you have a little town like one of the ones near me, you absolutely could look at that town and map around it. What are the activities? And come up with very similar protections for that town that you have for the one next door, where I have treated water available and we have protection. However, you're right that because the way that the rigorous regulations work for source water protection are based on a time of travel around that well, supplying the community, or the intake of surface water and how fast water can move from upstream, um, those times of travel are defined, and certain ones have more rigorous restrictions in terms of what can be allowed as activity in that area. But you still could have, for example, for sure, one of the basic threats for any place with a lot of private wells together is they probably all also have septic systems. So you could have a more rigorous septic inspection program in that community as a way of protecting the whole community. You also could look at the nearby factories that might be impacting that same aquifer and make sure they have good storage for their chemicals. So there are absolutely really, really productive things you can do in those contexts that are not harder to do than the municipal context.
Just to maybe make a quick reference, I don't think we have time to really get into it, but it feels like there's a lot more than just a discrete water issue here. And has been for a little while, a lot sort of around our environmental protections has been shifting quite dramatically. So for instance, if someone were to look at the wellhead protection zones on a map, they would often see sort of a teardrop shape, or a bullseye shape, right, with concentric zones where the vulnerability status is increased the closer it gets to the wellhead.
Yeah.
And the sort of purpose of that is sort of describing those water flows into that source point, and how sort of crucial they are, I guess, to the water that winds up there.
Yeah.
And that's also then the land activities and all the different things that happens in those areas are really crucial. But there's also, like, not just in the water area, there's also lots of other changes that have been happening that affect how and where sort of industry and different activities are able to occur, and the ease with which they're able to occur in Ontario, which maybe starts to get us into a little bit of trouble in terms of those, maybe not the wellhead protection areas specifically, but in these other less well-defined areas perhaps. But that's, yeah, maybe that's a discussion for another podcast. Do you want to get at move into a sense of kind of where we're at today in Ontario with our legislation? How have things shifted in the last in recent times, and then perhaps we can quickly look ahead to where things might go.
Sure. So, as I said, not everything that was originally envisaged out of Walkerton has actually been fully implemented as envisaged, and people can find out more about that in a report we did on the 20th anniversary of Walkerton. That's on our website. And things are adapting and evolving all of the time. But there have been a number of recent changes introduced by the province of Ontario that either have just passed or are in progress, and consultation is underway. And so we're definitely have been analyzing those from the perspective of protecting drinking water as well. And so, for example, the Clean Water Act itself was the subject of amendments that just passed within the last couple of weeks, really to do with changing and speeding up the way amendments to those source protection plans happen, especially to cover new supply coming on stream as development happens. So they will allow the source protection authorities to approve some of their own amendments, which is not something we disagree with. I do have some concern about new supply coming online before it's covered by a source protection plan. The Ministry of Environment says they'll make sure that there are protections in place in that case. So that's something we'll have to really keep an eye on. And we did encourage the time frame in that case for amending the plan to be quicker, so that we don't have supply sitting there without being covered by source protection plans. Another change that's underway right now that is somewhat related to source protection and the Clean Water Act is that the province of Ontario is consulting as we speak on a proposal to change conservation authority boundaries from 36 to 7 regional conservation authorities. And the reason that's related to drinking water in the Clean Water Act is it's the conservation authorities that are the secretariat bodies to the source protection authorities. It's an important part of their responsibility under the Clean Water Act. So we'll be looking at that and providing comment with an eye to making sure that there's no weakening of that role. The province says nothing will change, but we'll definitely be analyzing that closely. And another recent change that I think would have passed just yesterday with one of the bills being passed in the legislature is that there's a proposal. I don't know if you have a lot of farms with migrant workers in your area, but we certainly have many here in the south. And there's a proposal that for the sewage supplying migrant worker housing, this could be established through a self-registration system as opposed to a Ministry of the Environment oversight role. So we have a comment going in on that because we think that's not appropriate and could actually pose a risk to source water, especially because a lot of these areas will be places where other residents and farms around are on their own wells. And another recent change had to do with the potential to establish water and wastewater public corporations. According to the accompanying consultation, it's especially being established for Peel region, where the proposal is, if they move ahead, to move water and wastewater to the lower tier municipalities. And so we already did put some comments around that about it does keep the water in public corporations, but reiterating how important it is that our drinking water and wastewater systems be public in Ontario, and reiterating the importance of maintaining the responsibility of councillors in the municipality to exercise due diligence over water supply, among a few other things. So those are some recent examples. There were also quite a bit of concern by the public over a streamlining of water taking permits when they had it applied in the context where they had recently been revoked or canceled or not renewed within the previous year, and the ministry could reissue them without public comment. And so we did put in comment suggesting that the public should have the right to comment on those situations, including when the water taking permit is being transferred to a new owner. That last point is not something that the public automatically has the right to comment on already, but we think they should, because it could matter who the new water taker is in terms of their past compliance, their capacity to comply, and so forth. So those are a few things. There's been quite a bit underway in a short amount of time with a number of bills, and not all of those bills have gone to standing committee. Some of them have gone through to third reading with no referral to standing committee. So not even necessarily the time under the environmental registry posting to comment, and no opportunity to try to make deputations to the standing committee hearings or suggest amendments to the legislation.
Which, I mean, on a philosophical level, when you are interested in good information, so that you, for instance, know that your water isn't polluted, the water that you're drinking isn't polluted, and you're sort of soliciting that information from as many inputs as possible in terms of decision making at a democratic level, that seems like that's kind of being cast aside in this case.
I did say in one of our submissions that SELA is quite disappointed that there wasn't an opportunity for public comment and deputation because of the fact that both as a matter of public safety and also as a matter of public concern and interest, there is a high level of attention to drinking water, as there should be. That was one of Justice O'Connor's recommendations, that the public needs to be constantly vigilant. And so, in my view, every time there are changes that have to do with drinking water, they really should have a good, robust opportunity for public comment before they're finalized.
And it's one of those areas that is kind of notoriously difficult because, you know, by nature it's fluid, and it sort of transcends boundaries easily and things like that, right? So it's one of those things that is difficult to ensure is always the same.
One of the representatives from the water supply industry told me once that water is the best solvent around, which means that as it comes into contact with other materials, contamination can be transported, and unfortunately that can happen in ways we didn't expect, which is why we have such a robust system in place and why we all need to be, you know, constantly looking out to make sure we keep a really robust system in place, while at the same time we improve it to make sure there's better protection for those not yet covered by the existing system.
So I'm conscious that your time is limited, and I've already taken up about I think more than than what you indicated you had available. But would you be able to sort of quickly give us a sense, like your impression of or you know, if not yours personally, then Sela's, of where we are headed, you know, in the future, in the near future, in this province?
I think one of the common themes for a lot of the proposals that I've just described are that they're in aid of housing policy. And so, absolutely, we understand, you know, as a legal aid clinic, we understand the need for good housing policy. As the mother of 4 children in their 20s and 30s, I understand the need for good housing policy and affordable housing policy. So that's not the issue, but the question is, you know, one of the really critical things to pay attention to with new housing is the adequacy of the water supply, the safety of the water supply. And so looking at that question and whether or not just on the quantity side or quality side, but also on the quantity side, are we really thinking about how that water supply is going to be available in a changing climate, in groundwater dependent communities, you know, that are already stressed, and how the quality will be protected? And so that is one thing I think that's a dynamic in play, is that in the quest for additional housing supply, are we really doing a good job thinking about what's going to happen to protect our water for that future housing supply?
And lastly, it struck me the in the green room before, we were talking about red tape and how that's often used as a red tape reduction, and how that's often used as a justification for some of the policy changes, including prior to Walkerton. And it's interesting to me that, like, red tape often is done in the name of efficiency, so removing sort of what are deemed to be multiple barriers of bureaucracy. But then it's interesting that the result of Walkerton was this multi-barrier approach to enhancing and protecting public safety.
Yes, my colleagues and I will say that environmental and health regulation is not red tape. It's critical. It's critical infrastructure. And no, as I was telling you before we came on air, this is not the prerogative of any particular stripe of government or level of government. This is something that governments, federal and provincial, have pursued prior to Walkerton and ever since Walkerton, consistently, much to my dismay, I have to say, because one of the chapters of Justice O'Connor's report was about the fact that the red tape reduction efforts led to Walkerton. They were part of the causal sequence of what happened. So yes, the system that was put in place as a result, the multi-barrier system, is set up intentionally to make sure that there are multiple checkpoints, so to speak, that if one thing didn't work, this other thing is going to make sure that this tragedy doesn't result for the public. And as I said to you at the outset, we do have a good, robust multi-barrier system in place for drinking water in Ontario. We still do, despite all the other things I've been talking about. I'm constantly watching for that to make sure it's not fraying around the edges, and constantly advocating for it to extend to others who also deserve that protection. But at the same time, it can be easy to lose sight of how easily that protection can be lost when you make changes with one aim in mind, and you're not really paying attention to the probably unintended, for sure, unintended consequences that can result. I mean, none of the red tape issues that arose before Walkerton were ever intended to result in that tragedy, for sure. Yeah.
Yeah, but it's the unintended things that then become the problem. Yeah, and that's what the multi-barrier approach is intended to filter out.
Exactly.
Well, thank you so much for joining us, Theresa. It was enlightening, and definitely, I definitely learned a lot about our water system here, and yeah, I appreciate your time.
Yes, you're very welcome. Have a great day.
Thank you. You too. And